Sandy, with these two groups taking such an opposite position or such opposite positions, would you tell us under what circumstances would a physician be charged with the murder of a patient?
Steve, murders by doctors. Recently, you probably remember the publicized case that involved a murder charge. Many physicians came to the realization that a murder charge can arise from removal of a respirator, termination of intravenous feeding, discontinuing air mist, or removal of a nasogastric tube or intravenous, or any other act which may shorten the patient's life. You remember the case I'm referring to is the 1984 case where two California doctors barely escaped conviction for murder for discontinuing the life support system of a terminally ill patient. Medically, there was no point probably in prolonging that patient's agony of death in California. The choice was between killing or letting die. What led to the murder prosecution was not so much what they did, but how they did it. They disconnected the respirator to allow the patient to suffocate. Then they ordered the nurses not to use any endotracheal misting to help that patient breathe. And one physician actually personally removed the intravenous tube himself to starve the patient. And no pain medications were given or resuscitation. And the prosecution simply said that removal of the respirator and the intravenous amounts to murder, that any shortening of life is a homicide. And if it is intentional, then it should be construed as murder. So the decision by the prosecutors, whether or not to prosecute a physician, remember, is discretionary. But the prosecutors explained why they filed murder charges. The physicians had allegedly lied to the family about the condition of the patient. And they withheld information about a tremendous screw-up that occurred in the recovery room where there was insufficient nursing supervision. And also there was an apparent rush to take the patient off the respirator, and that was another factor considered. But the prosecutors noted that the most important reason for filing the murder charges was taking the patient off the intravenous, thereby dehydrating and starving him to death. And the prosecutors said that the victim was never given a chance to recover, and there was expert testimony to that effect. If nothing else, you know, that case reminded the medical community that no physician should pretend to be above the law, and that it is prudent medical practice to have consultation with other doctors. And the neurologist in this case reminded his colleagues before the event that it would have been prudent to consult the hospital attorneys. Instead, one of the accused physicians was quoted as saying, "I would fight to the death to keep bureaucracy and lawyers out of our medical group." Now, although the case of the two California physicians was derailed on technical grounds, but the possibility of similar charges somewhere in the United States may not be far-fetched.
When something like this happens, like you just described here, Sandy, would the physician typically be charged with murder, or would a lesser charge, such as manslaughter, be filed?
Most physicians are not charged with murders. You know, sometimes murder charges are filed, but most physicians are convicted of manslaughter, which results from death as a result of surgery, drugs, abandonment of patient, improper care or injection of drugs while the physician is intoxicated. An example of manslaughter conviction is a 1979 case where a psychiatrist sandwiched a patient between two mattresses and led at least 3 other persons in a mattress stomping session to stamp out complexes of obsession and fears that the patient had and was not able to communicate, particularly with women. Well, that patient suffocated to death. In another case, the Wiener case from New Jersey, a physician was convicted of involuntary manslaughter because of the death of 15 patients from hepatitis after having received intravenous injections. But he was acquitted on all counts. He was convicted of 3, but they were reversed because there was insufficient evidence. Remember, the burden of proof requires beyond reasonable doubt. That test was not met by mere carelessness and negligence. Carelessness and negligence would be enough evidence to win a malpractice lawsuit for damages, but not a conviction for manslaughter or murder. Now, prosecution for manslaughter against a physician may result also in a conviction where a doctor had a duty to provide medical attention, but refused to do so because of the physician's financial inability to pay. There, the court found that the public assistance was available, and the appeal sustained the conviction.
When, Sandy, will a physician be held liable for criminal negligence?
Criminal negligence? It's long been recognized that criminal liability of a physician can result from a high degree of negligence. What the law calls criminal negligence is largely a matter of degree, almost incapable of precise definition, and whether or not criminal negligence exists is a question that is left for the jury. It requires a showing of lack of competency, gross inattention, or wanton indifference to the patient's safety. This may arise from ignorance of the sciences of medicine and surgery, or through gross negligence either in the application or selection of remedies, lack of proper skill in the use of instruments, and failure to give proper attention to the patient. The law recognizes that care or treatment of a sick or injured may be so reckless or wanton that the death resulting from it may be the basis of a murder conviction. However, most courts have felt that in a prosecution for murder, circumstances must show an abandoned and what is called malignant heart, a showing of intent, which is extremely difficult under medical circumstances to prove. What has happened, in fact, is that the courts look for an objective rather than a subjective standard in determining whether the defendant acted with conscious disregard to the patient's life.
So we know that doctors are human beings and they can't always be right. How does the law allow for mere mistakes that may occur?
They are handled differently, mere mistakes. The courts are careful not to hold doctors responsible for the death of patients resulting from mere mistake or judgment in the selection or treatment of that patient, and the death may have resulted from an error in judgment or inadvertent mistake. The view that a mere mistake or want of skill which may result in death, here if there was no intentional act and it was merely a mistake, then the doctors are not liable. And this has been affirmed in Idaho case by U.S. Supreme Court in one of its cases.
What charges might physicians face in abortion cases, Sandy?
There are a multitude of convictions involving doctors that have done abortions and women died. But many of these, Steve, occurred before abortion was legalized. Part of the basis also was the illegality of the abortion. But even in therapeutic abortions, courts have found criminal negligence when the physician did not exercise that care and circumspection required in such cases by failing to consult, say, with a cardiologist when needed, or using general anesthesia, or tearing and puncturing the cervix, or lacking adequate emergency facilities when the procedure was performed in the doctor's office. Another aspect is the unborn child. Injury to the unborn child has long been recognized as a crime, but recent focus on abortion as a national issue has increased the potential exposure of physicians to charges of feticide and infanticide. Feticide, which is the destruction of the life of the fetus, is recognized as a separate crime by the laws of some states, such as Missouri and Georgia. Persons responsible for the death of unborn children may be prosecuted for the crime of feticide, where the intent to kill is established. And some states have statutes that provide criminal penalties for inducing or procuring an abortion, and there is an unborn child that dies, or the mother. Now, when the courts construe abortion statutes, the courts have held that an essential element of a crime of killing a fetus is that the fetus must have been quick in the womb, capable of viability. And thus the issue in such prosecution has generally been whether or not the fetus has become quick. The incidents for such prosecution, especially against physicians, have drastically declined, though, since the U.S. Supreme Court has legalized abortion, at least in the first trimester of pregnancy. And this is based on the Roe versus Wade and the Dunford cases of 73 and 76, respectively.
Recently, we've heard a lot about regulation of the medical efforts used for severely deformed or retarded babies. What is the general consensus of physicians on this issue?
The medical community has been virtually unanimous in condemnation of the federal government's proposal in the baby doe cases and lawsuits. You know, these would send federal criminal investigators rummaging through medical records and allow discontented nurses, aggrieved patients to second-guess in court what extraordinary treatment should or should not have been administered, or what surgery was done, no matter what the cost to society or how little the child's life may be prolonged. Moral, ethical, and religious issues for which neither the medical sciences nor society have found an answer are going to be adjudicated in criminal courts.
Can a physician be held liable for failure to report a suspected infant murder?
Yes. There are problems when dealing with the sudden infant death syndrome, for example, as a cover-up for homicide. A Texas coroner recently charged that the sudden infant death syndrome in infancy is not a diagnosis. What it really means is that no one knows why these children died. And he concluded that there is no way how such deaths could be traced to, and how many of them were homicide. Physical evidence in a baby killed by suffocation or smothering is hard to find. Now, by not reporting cases suspected of sudden death infant syndrome, there may be liability that the physician may be an accessory to the crime. However, there have been no such cases reported to my knowledge.
What are the tests that the court considers in criminal liability?
Well, let me give you an example first, and then we'll go through the tests. In an Arkansas case, the Supreme Court affirmed an indictment for manslaughter in the Hardester case. And in that case, the defendant and his co-defendant were doctors, physicians, and obstetricians, and they held themselves that way to the public. They attended to a pregnant woman. The defendant physician and the co-defendant who aided and abetted him were found guilty of felonious conduct, which was without doubt resulting from malice and using appliances that were improper and then abandoned the patient and resultant in death. The Supreme Court of Arkansas spelled out the tests of criminal liability and said that the evidence must show that the physicians were grossly ignorant of the art that they are practicing, or that they showed manifest ignorance in the selection or application of remedies, or that the remedies were unusual, inapplicable, or rashly applied, or that the defendants were grossly negligent or inattentive. And those are the tests that are used.
Okay. Sandy, let's have you now discuss some of the lesser criminal charges that may confront a physician.
In another case that was publicized in California was the Bouvier case, where the DA refused to press criminal charges against a battery of physicians and nurses who were force-feeding a patient that was quadriplegic. That was the Bouvier case. She sought injunction to stop the feeding, and she claimed a right to starve herself in dignity while she was in the hospital. The fact that she did not succeed, civilly or criminally, is incidental, but technically the physicians and nurses could have been found criminally liable for battery for the unauthorized forced feeding by intravenous, in this case, where the patient was not legally incompetent. This may be far-fetched, but we don't know how other courts may hold in similar cases in the future.
I understand that the greatest number of criminal prosecutions against physicians concerns the prescription of narcotics. What guidelines should a doctor follow in the administration and dispensation of medications?
You know, the boundary between medicine and good medicine or practice of medicine and crime is sometimes thin, and this is particularly present in administering drugs. Most states have adopted the Uniform Narcotics Acts and Uniform Controlled Substances Act, which are modeled on the Federal Controlled Substances Act. Here, issuing prescriptions to the same patient under different names and different addresses is sufficient to convict a physician. For example, in the Greenfield case, there was no entrapment when the individuals from the Narcotics Bureau were investigating the physician. In other cases where prescription of controlled substances without examination of the patient or inadequate examination or inappropriate prescriptions will also result at times in conviction.
Tell us, Sandy, how successful are criminal prosecutions where improper or immoral conduct by a physician toward a patient is alleged?
Here we're talking about things like rape and other sex assaults and so on. In cases involving psychiatrists, for example, there are difficulties in prosecuting such cases. Psychiatric patients have little credibility with juries, but periodically we hear of rape and intimate therapy in revocation of license proceedings. Another obstacle to criminal prosecution is the embarrassment and unwillingness of patients to testify, except in, say, cases of minors or unusual circumstances. The defense is that the actions were consensual. In discussing sexual abuse of a female patient by a psychiatrist, a New York court pointed out that it is its function to protect patients from malicious abuse of power and by psychiatrists, where the patient entrusts the person and the mind to the psychiatrist to effect a cure. And in forcible sexual abuse and assault, the court concluded that where allegations involve certain violations of penal statutes, then the courts would apply such convictions. Take, for example, child molestation. That is enough to revoke a pediatrician's license.
Can you tell us about cases where beatings have been administered under the ruse of so-called therapy? Well,
here we are dealing with a psychiatrist, again, using beatings, and then send a bill for $55,000. And here a situation arises where the beatings can occur by other individuals. For example, a psychologist and a college professor who was beating his 15-year-old niece with paddles while she lay across his lap. And he also whipped her with a leather belt. It is a dilemma for prosecutors. Many claims of beatings, as well as rape and sexual abuse of psychiatric patients, particularly in institutions, are of suspect reliability. And in case of mental patients, it's very hard to differentiate fabrications from truths unless there are independent corroborative evidence that one could produce.
What results when a physician falsely issues a death certificate or fails to report unusual or suspicious deaths to the medical examiner?
This often, Steve, occurs when the physician wants to spare the family's feeling or hardship. Such a situation may arise in cases of overdose. In most states, it is a misdemeanor not to report death under suicidal or unnatural circumstances to the coroner or medical examiner. And in most states, there are misdemeanor charges for failure to report to the medical examiner or coroner all matters of violent deaths from radiation, death due to criminal abortion, whether they are self-induced or not, or deaths unattended by the physician, deaths of persons, say, after unexplained coma, or medically unexpected deaths that occur during the proper medical therapy, death of inmates in penal institutions, and say deaths of persons who are going to be cremated and buried at sea or transported out of state. And these, particularly when they are going to be available for or unavailable for pathologic studies subsequently. Also, there may be failure to report diseases that may constitute a threat to public health. Here again, these have to be reported. Otherwise, there may be some misdemeanor charges.
What litigation results from false medical claims?
One of the more vigorously prosecuted areas now is the suspicion by healthcare providers of fraudulent claims under the Medicaid and Medicare program. It is a felony to knowingly make false statements that are material in Medicaid or Medicare claim. Now, there have been relatively few cases that have been filed involving the federal government, but physicians should be aware that criminal responsibility may arise from any material false statement, not only to the federal government and the state government, but also to private insurance companies. In most instances, the convictions for such fraud will automatically result in suspension or revocation of the medical license.
We know that another case of medical fraud involves miracle cures which have no scientific basis. How are cases of fraud in this area handled?
The prosecutions are made routinely against physicians who make such false promises of cures to patients, either through the mail or by telephone. These carry severe penalties, and in certain instances where multiple violations are involved, physicians who promise these may face the charge of other acts, the RICO, for example, Act, and such prosecutions involve not only penalties and stiff fines, but also permit the government to trace assets and forfeit, say, condos or automobiles or yachts or other things that may have been purchased with the illicitly gained funds.